Welcome to the second edition of our Breaking Ground series. My name is Andrea Lynch and I'm a Principal Associate specialising in construction and engineering risks within our insurance disputes practice at Mills & Reeve. I'm joined today by my wonderful colleagues, Laura Johnson and Adrian Kwintner, who also specialise in construction and engineering risks. Good morning, both.
Morning, Andrea.
Morning.
In this session today, we will focus on the scope of cover of a typical professional indemnity construction risks policy by looking at how a typical insuring clause operates. At the end of the session, we will consider a hypothetical case study arising from a typical construction project to practically apply the principles discussed today. This session is being recorded, and whilst you can see us, we cannot see you. So Laura, what do we need to know about the insuring clause in a typical construction professional indemnity policy?
Well, Andrea, I thought the easiest thing to do here was to put a typical insuring clause on the screen, so everyone should be able to see one on the slide now. Given that it sets the context for today's talk, I'll just read this clause out and we can discuss after. So this one says, insurer shall indemnify the insured up to the indemnity limit for the amount of any claim, including the claimant's costs and expenses, first made against the insured and notified to insurers during the policy period in respect of any civil liability arising out of the exercise and conduct of the activities and duties by the insured and/or consultants.
Right, Laura, so there is a lot of information there. Can you break that down for us?
Yeah, I mean, you're absolutely right, Andrea. It does at first glance look like a lot of text, but I do think we can probably just break it down really easily into 5 basic elements. And those are, shall indemnify the insured, claim first made, notified during the policy period, civil liability arising from activities of the insured.
Okay, so Laura, looking at the first element there, the wording shall indemnify makes it sound like it's some kind of guarantee to the insured.
Well, Andrea, the word shall is actually important here because the insurer has an obligation rather than a discretion to cover the insured if all of the criteria are satisfied. But I think with this one, another key point to note is that it's important to check exactly who is named as an insured in the policy and who isn't. So for instance, larger organisations may well have multiple subsidiaries, which are all usually named under the policy. Equally, however, they may not be. On some large project policies, you might find that other parties to the project, such as subcontractors, are also named as insureds. So whilst in theory this all might seem very obvious, in practice it really is essential to check whether those claiming are named and covered. The details in the schedule of the policy and any endorsements will confirm this.
Thanks, Laura. That makes sense that you first must ensure all the entities are named to ensure that they're going to get cover. So what exactly does claims first made mean?
Well, Andrea, a PI policy will usually provide for claims first made during the policy period. So any claim for which the insured seeks an indemnity must have been first made during the policy period. A claim is a defined term in the policy and typically describes the point at which a claimant sends a formal claim to the insured. This tends to be at the pre-action stage, but can include earlier stages in the dispute, which has or is about to arise, which causes the formal claim to be made.
So, Adrian, are you saying that the insured only needs to notify if it receives a formal notice of claim?
Well, not quite, Andrea, and this is why it's very important to check the terms of a policy, as most PI construction risk policies will define a claim as a claim or circumstance which might give rise to a claim to insurers. The word circumstance is also likely to be defined in the policy and could include anything from an initial complaint to the discovery of an issue that could lead to a future claim.
So the timing of notification is absolutely key, as it could prejudice whether cover is available. So what is the relevance of the wording and notified to insurers during the policy period?
Well, I mean, Andrea, first and foremost, the claim will only be covered under the policy if the insured notifies the claim or possibly a prior related circumstance to insurers during the policy term. In the case of construction PI claims, the sooner an insurer is notified of a potential civil liability having arisen, the sooner they can help its insured to resolve it. So, for example, at its extreme, this might be where remedial work is required urgently in the case of a catastrophic leak or a collapse. or it could simply be where claims assistance is required urgently if litigation or an adjudication has commenced and timescales are really tight.
Thanks, Laura. You mentioned the word civil liability there. Can you explain what is meant by civil liability?
Civil liability will cover situations where the insured may be held liable for a loss due to violating a civil law or due to negligence or a breach of contract. I should point out that an insuring clause in a contractor's design and build policy tends to have different wording than, say, for a consultant's design and construct policy, such as for an engineer or an architect.
And why is it different, Adrian?
Well, as the slide shows, the insuring clause in a consultant's policy is usually drafted on any civil liability basis, and so tends to be quite wide. In contrast, the insuring clause in a design and build policy tends to be limited to something along the lines of civil liability for any negligent act, error, or omission. The main reason for that difference is that contractors are not limited to providing professional services subject to reasonable skill and care. What we mean by that is that their obligations often include obligations to build something in a certain way and to a specified standard, and those obligations will not be subject to the standard of reasonable skill and care in the same way that a consultant's contract will be.
Thanks, Adrian. You've mentioned there quite a few times the standard of reasonable skill and care. Can you just elaborate a little bit on what that means?
Yeah, good. It's a good point. It's the term used to define the standard of service which is expected to be provided by a professional. A professional person will be expected to carry out their activities to the same standard as another reasonably competent member of their same profession. An architect is held to the same standard of care as another reasonably competent architect, and an engineer to another reasonably competent engineer, and so on.
Thanks, Adrian. So turning now to look at the final element of the insuring clause, which is arising from activities of the insured. Now, what exactly is meant by the term activities?
Andrea, the activities of the insured are usually specifically set out in the schedule to the PI policy, particularly in the case of design and build contractors. So examples of these activities in the case of a design and build contractor could be designer specification, supervision of construction, feasibility study, technical information calculation, surveying, etc. And often the schedule will specify that the activities also need to have been undertaken by a professional person with particular qualifications. And this clarifies that the cover is only provided in respect of claims arising in relation to the insured's professional obligations. And this is why it really is so important that all of the activities carried out by the insured are listed in the schedule. If the insured decides to perform activities that aren't listed, then it's very likely that those activities won't be covered. I think, Andrea, it's also worth flagging at this stage that professional services is also usually defined in the policy. Generally, that definition will be something along the lines of design or specification and related activities, but it's really important to check exactly what falls within the professional services definition and what might be excluded.
Thanks, Laura, and thanks, Adrian. Now that we've looked at the 5 basic elements of the insuring clause, we thought it would be really helpful today to join this all together by looking at a practical case study to demonstrate how issues can arise which may affect the scope of cover. You will be able to join in as we will be running some polls with some questions, but don't worry, it's completely anonymous. So turning to the facts of the hypothetical scenario. So a developer called CreateSpace employs Done Right, apologies for the names, as its main contractor in relation to the design and construction of a multi-story office. Done Right, the contractor, enters a subcontract with Sparks Limited in relation to the design and installation of the air conditioning system. In 2021, Done Right received a formal letter of claim from the employer CreateSpace in accordance with the pre-action protocol for construction and engineering disputes. It is also relevant to know that Done Right is a wholly owned subsidiary of the parent company, DR Holdings Limited, and it was DR Holdings Limited that placed the professional indemnity policy. So turning to our first question this morning for the audience, do you think that Done Right would be considered as an insured for the purposes of the policy? Now we've got a couple of answers here. So A, yes, a wholly owned subsidiary is insured in the same way as the main policyholder. B, no, it's an entirely different entity and for the purposes of the policy. Or C, it depends if the policy, it depends if the entity has been named on the policy. I'm just going to give people a few minutes to vote. Quite a high number of people are going for C.
That's right.
There's quite a mixed bag though coming through now.
Yeah, some think a wholly owned subsidiary is insured in the same way as the main policy owner. Laura, what's the correct response?
Well, Andrea, I'm just looking at the responses here, and it looks like most people have gathered that it depends on whether the entity is named in the policy. So this set of circumstances is actually based on a previous case of ours. Obviously, we have changed the names. But in that case, the insured was defined in the policy as BR Holdings Limited, including subsidiary and predecessor undertakings. Now, in reality, there may be questions regarding the definition of subsidiary and predecessor for the purposes of the policy. However, for today's session, let's assume that done right satisfies the definition of subsidiary and is therefore covered.
Great, thanks, Laura. Looking now at the next stage in the case study, in January 2021, Done Right receives a formal claim from CreateSpace. However, it turns out that in 2019, CreateSpace had sent several emails to Done Right complaining about the air conditioning system and had asked Done Right to return to site, inspect the system and remedy the issues. Done Right had ignored these emails as there was no mention of a claim and they had simply thought the issue had gone away. So before we turn to the next question, it's important to look at the policy wording as to how a claim is defined. So in the Done Right professional indemnity policy, the claim is defined as any written demand for compensation in respect of a wrongful act, often insured. So our second question this morning is, when do you think the claim will be considered first made by the policy? We should see a poll on the screen. So again, we'll give people a couple of minutes to vote. So the answers are A, 2019, B, 2021, or C, it depends on the wording of the policy.
It looks like a lot of people are going for B on this one.
Yeah, it's actually really, yes, it's almost at a third for each of them. So yeah, quite a mixed bag. I think the voting seems to be levelling off. So Adrian, what's the correct answer?
Well, probably not surprising, Andrea, but the answer is B, 2021. In this particular case, and as you can see on the slide, claim is defined as a written demand for compensation. The 2019 emails didn't fall within the policy definition of claim because there was no demand for compensation at this stage. So on the basis of this particular policy, the claim was first made in 2021 when the formal letter of claim was received. That said, we have seen policies where claim has a different definition. And so it's very important for construction professionals to carefully consider the policy wording to determine when a claim has been made.
Great, thanks, Adrian. So moving on now with the next set of facts, it transpires that in 2019, when the emails of complaint were received, Done Right had in fact discussed them with both their in-house legal team and their broker. However, neither Done Right nor the broker notified the emails to insurers. Currently, you will see on the slide the wording of Done Right's notification obligations under its policy. The wording is as follows: as soon as reasonably practical during the policy period, notify the insurer of any circumstance of which any insured becomes aware during the policy period which may give rise to a claim. So turning to our next question this morning is whether you think the 2019 emails, when you think the 2019 emails should have been notified. Slightly simpler this time, A for yes, B for no.
Yeah, 50-50 shot on this one.
Okay, so A lot of big people voting on this one. There's an overwhelming response, which is yes. Laura, what's the correct answer?
Well, Andrea, as most people have answered here, it's yes. So in this particular case, and as you can see on the slide, the policy stated that done right is required to notify any circumstance which may give rise to a claim. So in this policy, circumstance wasn't separately defined beyond this. However, the use of the word may means that a fairly low threshold will apply in terms of what should be notified. Consequently, the 2019 emails are likely to be classed as a notifiable circumstance, given that Create Space raised an issue with Done Right and asked that they return to site to remedy it. The implication there is that if the issue wasn't remedied, they would look to Done Right to pay for the remedials. And that certainly suggests that the issue may give rise to a claim and should therefore have been notified in 2019.
Yeah, definitely, Laura. Thank you. So finally now, back to our case study and to what will be our final set of facts this morning. So whilst investigating the reason why the air conditioning system was defective as part of the claim, an expert determines that the issue is due to the negligent design of the electrical ducts that were connecting into the air conditioning system. Now, Sparks Limited had been retained for the design and installation of the air conditioning system itself. However, it transpires that Done Right had in fact carried out the design of the electrical ducts connecting into the air conditioning system in-house. Done Right's professional indemnity insurers were not aware that Done Right carried out any electrical design work in-house. This did not fall within the definition of their professional services, nor was it listed as one of Done Right's activities in the policy. So our final question this morning is, will the professional indemnity policy cover Done Right's negligent design in relation to the electrical ducts? Well, people are straight on this.
Yeah.
Another 50-50 chance on this last poll.
Yeah.
The numbers are shooting up for this one.
Yeah, straight on it. Fine, it looks like last few votes to be counted. Yeah. So, Adrian, what's the correct response?
Thanks, Andrea. Well, we thought we'd end with a fairly straightforward question. The answer is B, no. The duct design work will not be covered as insurers had not been informed about this before the inception of the PI policy. And the PI policy wording does not encompass electrical duct design. As we mentioned earlier, the insuring clause for design and build contractors tends to be limited to civil liability arising out of their professional obligations. What all of these questions show is that it's so important for construction professionals to be aware of the wording of their policy and to have meaningful discussions with their broker when any issue arises, or indeed prior to policy inception, to ensure the policy is adequate.
Great. Thanks, Adrian, and thanks also, Laura. Well, folks, that's all we've got time for today. Thank you so much for joining us this morning. In our next session on the 16th of June, my colleagues Andrea McConnell and Aaron Matthews will be delving into detail on typical exclusion clauses found in a professional indemnity policy in the context of construction risks. We hope you will be able to join us then, and we wish you a good rest of the day.